What is a warrant? The term warrant has not been defined under the code. Warrant is basically a written order of the court directed to a police officer authorizing him to do a particular act. Warrant can be of different types, such as search warrant, distress warrant, arrest warrant, etc. In this lecture, we will be talking about warrant of arrest. A warrant of arrest may be defined as a written order of the court, directed to a police officer, authorizing him to arrest a person named in the warrant, and produce him before the court. Warrant of arrest is one of the modes to secure the presence of the accused before the court. A warrant of arrest may be bailable, or non-bailable. Let's take a look at the contents of a warrant. First, the warrant has to be in writing. A court cannot verbally ask a police officer to arrest a person. The court will have to issue a warrant in writing. Second, just like summons, warrant too is issued in duplicate. This means there has to be 2 copies of a warrant. Third, warrant has to be signed by the presiding officer of the court. This means, a warrant has to be signed by the judge or anyone authorized by the judge to sign. Fourth, the warrant must have the seal of the court. Fifth, the warrant must clearly identify the person to be arrested. Sixth, the warrant must state the offense for which the person is to be arrested. Lastly, the warrant must state the name and designation of the police officer who is authorized to execute the warrant. Remember, the summons is directed to the person who is supposed to appear before the court. But the warrant is directed to the police officer who is supposed to arrest the person. So, the warrant must comply with all of the above requirements, otherwise it will be invalid. For example, if the warrant of arrest does not have seal of the court, it will be invalid. All the requirements as to the content of the warrant must be complied with. Let's now talk about the format of the warrant of arrest. Format of warrant of arrest is given under Schedule 2, Form Number 2. Take a look at it. Now, the question is, how long a warrant will remain valid after it is issued? Well, a warrant has no expiry date. Once the warrant of arrest is issued, it remains in force until it is executed, or cancelled by the court which issued it. If the warrant could not be executed, the court may ask for reasons and send back the warrant again for its execution. If there is any lawful reason for not executing the warrant, the court may cancel the warrant. Take a look at the cancellation of warrant of arrest of famous Bollywood actor Sanjay Dutt. Now, Section 71 to 81 deals with mode of service of warrant. Section 71 deals with issuance of bailable warrants. Section 71 says, when a court issues a warrant of arrest, the court has the discretion to direct that if the person against whom the warrant is issued executes a bond with sufficient sureties for his attendance before the court whenever required, he may be released from the custody. So, when the court issues a bailable warrant, the person is first arrested by police. If the arrested person executes a bond and provide enough sureties, he will be released from the custody of the police. The police officer shall forward the bail bond to the court which issued the warrant. Now, is the warrant of arrest always directed to a police officer? Can a warrant of arrest be directed to a person other than a police officer? Well, Normally a warrant of arrest is directed to a police officer because the police officer has the ultimate authority to arrest a person. However, in situations where there is no police officer available to make the arrest and the immediate arrest of the person is required, the court may direct a person other than a police officer to execute such warrant of arrest. A warrant may be directed to more than one police officer or person. In such cases, all of such officers or persons get authority to arrest, and the person can be arrested by all of them, or by any one of them. Now, another question. Can a police officer, who is directed to execute a warrant of arrest, delegate his responsibility to another police officer? The answer is yes. A police officer who is directed to execute the warrant of arrest may endorse the name of the other police officer on such warrant, and then such warrant of arrest can be executed by such other police officer. We have seen before that a court can direct a person other than the police officer to execute the warrant of arrest, but only when no police officer is available. But Section 73 talks about situations where the court can direct any person to execute warrant of arrest, irrespective of whether the police officer is present or not. Section 73 says that a chief judicial magistrate or a magistrate of first class can direct the warrant to any person to arrest 3 types of persons. First is an escaped convict. Second is proclaimed offender. And third is person accused of a non-bailable offense and evading his arrest. Such person is required to execute the warrant when the person against whom warrant is issued enters on any land or other property under his charge. The person executing the warrant will notify the substance of the warrant to the person to be arrested and show him the warrant. A warrant can be executed anywhere in India. When the warrant is to be executed outside the jurisdiction of the court issuing it, for example, a Delhi court issues a warrant to arrest a person from Mumbai. In such cases, warrant cannot be directly executed. This is because a court's power is limited to its local jurisdiction only. In such cases, the executive magistrate or the police officer of the jurisdiction where the person is to be arrested needs to be involved. There are 2 ways of executing a warrant outside the local jurisdiction of a court. First, the court issuing the warrant can direct the warrant to a police officer within its jurisdiction. Such police officer will then take such warrant for endorsement to an executive magistrate, or to a police officer not below the rank of an officer in charge of a police station, within the local limits of whose jurisdiction such warrant is to be executed. Now, the second way. The court issuing the warrant may directly send it by post or otherwise to the executive magistrate, or district superintendent of police or commissioner of police within the local limits of whose jurisdiction warrant is to be executed. Now, to avoid any misuse of authority to arrest a person by the police officer or any other person, Section 76 requires that the police officer or any other person executing a warrant of arrest need to produce the arrested person before the court without unnecessary delay. In any case, the delay should not be more than 24 hours, plus the time taken in the journey to bring the arrested person before the court. When a person is arrested outside the district in which the warrant was issued, the arrested person is required to be taken to the executive magistrate, district superintendent of police or commissioner of police of that district. However, if the court issuing the warrant is within 30 kilometers of the place of arrest, or if the court issuing the warrant is nearer to the above officers, the arrested person need not be taken to these officers and can be directly taken to the court. For example, if a court in Ghaziabad issues a warrant to arrest a person in Gautam Buddh Nagar, then the arrested person needs to be taken to the executive magistrate, district superintendent of police or commissioner of police in Gautam Buddh Nagar, because Ghaziabad and Gautam Buddh Nagar are two different districts. When the arrested person is taken to the executive magistrate, district superintendent of police or commissioner of police, as the case may be, such officer will send him to the custody of the court issuing the warrant. However, if the arrested person is accused of a bailable offense, and such arrested person is ready and willing to give the bail, or if the arrest warrant states about taking of security, and the arrested person is ready and willing to give security, the arrested person should be released on bail, and the bail bond should be forwarded to the court issuing the warrant. If a person is arrested for a non-bailable offense, then only Chief Judicial Magistrate or Session Judge can decide to grant the bail, after considering the relevant information or documents. Warrant is an order of the court. Hence, any resistance or obstruction in the execution of the warrant is a punishable offense under the Indian Penal Code. However, if the warrant is not validly issued, or if it is not complete as to its contents, then it will not be unlawful for a person to resist such warrant.